Ladies and gentlemen, just as a reminder, make sure that all your cell phones, electronic devices are turned off, please.
Mr. Griffith, step down. Mr. Griffith? All right, counsel and defendant are present, and Mr. Hartung just raised his hand. Does counsel know what he wants to speak about?
Your Honor, I would like to respectfully ask for a mistrial based on the information that I have here and the statement that I would like to give.
You can sit down, sir. You don't have to stand up.
Based on this information that I have here, I wrote this yesterday, Your Honor.
Okay, have you talked to your attorneys about it?
I have not, because it concerns them, sir, so there was no point in me talking to them about it. They had already told me that I couldn't even ask for a mistrial.
Well, they are correct in that legally they're in control of the process of the case, but if you want to tell me something, you're not.
I would certainly love to read you this statement, Your Honor.
And is that a statement of your own?
I have a statement of my own, and I also have a key for you, sir. This key is
Wait,
to my deposition.
stop. If you're going to tell me evidence or facts, you're going to have to be sworn in.
I thought I was still sworn in.
That's true. You are. You were sworn in earlier in the case.
Yes, sir.
So, counsel, want to say anything before he starts talking?
I have no idea what he's going to say.
Sir, I'm going to give you one caution, and then you have the right to do whatever you want. I would recommend you speak to your attorney before you say anything.
I've already talked to him about this, Your Honor.
All I'm doing is giving you my cautionary statement.
Yes, sir.
So, however, you have the right to speak, and anything you say can be used against you, and everything's being recorded.
Yes, sir. I have here a key. This is to my depositions. This key was written almost 3 years ago. I also have here, on this key, you'll see that the date, every piece of evidence that I got was hand numbered by me. Okay? In other words, all of my depositions, all of my discovery, and all of the documents that I got, including my amended discovery, were hand numbered with qualifiers by me, so that if I gave you all the information that I had for my notes and you threw it right out there on the floor, I could grab it and put it right back together in just a matter of minutes. Even if you mixed amended discoveries with discoveries which had the same page numbers at the bottom. But you're going to see on this sheet that there's 595 pages in the depositions. You're going to see line numbers. You're going to see page numbers. You're going to see that, like, for instance, page 200 and let's say page 171S was that's where Matthew Winfinger's deposition began. Okay? Over here you're going to see page 102, line 24, page 124, line 14. This was written almost 3 years ago when I had my depositions. Okay? I have a statement that I would like to read to you, and I would like to pass this up to you, if I may, so that you can look at it.
What's the significance of that?
The significance of this, sir, is that it backs up what I've got written here. This is the actual depositions, and also the discovery that was hand numbered. I can goes with what this statement that I'm going to make to you, that I'm going to read to you.
Why don't you hold it until you do your statement?
All right.
We'll see where it goes.
Would you like to hear my statement? I'm offering this statement in support of a mistrial, Your Honor.
Okay.
I'm asking also that you reconsider the Nelson hearing that I asked about, Mr. Griffin, at the very beginning of this. The fact that I told you that I asked for a Richardson's hearing because there's so much exculpatory evidence that has not been presented in this trial. I also ask that you consider a Nelson hearing for Mrs. Wilson. Causes will be in this letter, if I may.
Yes, you asked me if I want you to say it. I don't want you to do anything, but you may voluntarily tell me anything you wish.
All right, so I'd like to read this statement to you.
Okay?
I ask that I not be interrupted during the statement. I'd be happy to answer any questions afterwards.
I'll try not to.
On October the 27th, 2015, I was arrested and charged with 3 counts of first-degree premeditated murder in the deaths of my mother, Voncile Smith, my 2 brothers, Richard Thomas Smith and John William Smith. I have maintained my innocence throughout the last 51 months. Shortly after my arrest, I was informed by Michael J. Griffith, my attorney, who had been retained by a $10,000 payment, that in probate court, Judge Edward Nicholson had invoked the Florida Slayer Law on my family's estates, which was being processed at that time by Bentley M. Fisher of the J. Mark Fisher Law Firm in Pensacola on East Government Street. The only will known to exist until this day was written by my mother, Voncile's attorney, in 2009. This will was discovered by family members during a search of the victim's home shortly after the crime scene was cleared to be reopened. At no time had I ever seen my mother's will. This will was taken to the office of Attorney Gary Leachman and his assistant, Mr. Lojo. Mr. Leachman rolled the will over his finger and asked if a name visible on the will was my name. I then looked at the will and saw the name Donald Wayne Hartung, Jr. before my eyes. Present in the room was John Henry Watson, my first cousin, and Wanda Hamel, the wife of my first cousin, Carlos Hamel, who was deceased. At that time, I recalled the conversation that I'd had with my mother on Tuesday after my dad's funeral was held at Barrancas National Cemetery on board NAS Pensacola. In this conversation, which was, I believe, January of 2012, it may have been 2013, my mother revealed to me that she had purposely written my son, Don Jr., out of her will. She cited the reasons. Number one, she was upset about an incident that occurred in 1995 when my son attacked me and hit me with a baseball bat. But more, I believe, important to her was the anger that she felt because Don Jr. had not attended his granddaddy's funeral, which should have at least sent a card. He should have at least sent a card or flowers, according to Mother. Mother never met her only great-grandchild, Angela Rose Hartung, who was abandoned by her mother, Teresa, as a baby, and was raised by my wife, Peggy Lee Hartung, who lives in Moyock, North Carolina now. That's my ex-wife. Although he was requested, Donald Jr. would not send photographs of this baby, who is currently 19 or 20 years old. Shortly after my arrest on October 27, 2015, my attorney, Michael Griffin, visited me in jail and brought and went to my house, got extra checks, and then he retrieved from my home, which was at 6730 Klondike Road here in Pensacola, Florida. For the past 20 years, I've maintained my residence, Your Honor, right up until October 31st, 2019. Mr. Griffin had been paid his retainer a couple of months before my arrest. Again, that retainer was $10,000. I agreed to write 3 checks at that meeting to Mr. Griffin for use in my defense. 1 check was for $65,000, and 2 checks were for $10,000 each, which were drawn on my account at Bank of America, which brought the total receipt up to $95,000. And you will recall, sir, in a hearing that he told you that he had received about $70,000 pay. After this payment, Mr. Griffin informed me that expert witnesses would be needed in my case. Judge Edward Nicholson had frozen my use of estate funds after a $119,400 distribution had already been received by me from Bentley Fisher of estate money. This money was in my bank account at Bank of America. I never tried to hide the fact that I received it as a legal distribution. This money was in my bank account at Bank of America. Michael Griffin procured the services of attorney Mark Bednar, currently, at that time, he was located at the Federalist House, whose office is at the Federalist House here in Pensacola, or it was at that time. Mr. Bednar acted as a go-between, attending probate meetings with Mr. Bentley Fisher, supposedly on my behalf. Since I objected to Judge Nicholson's use of the Florida Slayer Law, and since I had not been convicted of any crime, Judge Nicholson ordered that since Donald Jr. was the next heir, and since I had been arrested and charged with these murders, that Donald Jr. be required to send a letter that he had no objection to my use of estate funds, which Jr. did. This letter was withheld from me. I accidentally found it one day when I just grabbed Mr. Bednar's stuff and flipped it open, and it flipped right, just happened to land right on that letter, and I said, "What is this?" I had been arrested and charged with the murder that Donald Jr. be required to send a letter that he had no obligation to my use of estate funds, which Jr. did send by a probate. Then Judge Nicholson ruled that since the letter sent by my son was not of an attorney's letterhead, and that there was no mention of his consultation with an attorney, that his consent was not acceptable, and that Judge Nicholson then ruled that I could receive relief from all 3 estates, provided an equal amount, dollar for dollar, was provided to Don Jr., my son. Now, Michael Griffin and Mark Bednar then requested a $250,000 distribution from me and consequently this would result in a $250,000 distribution to Donald Jr. I refused this request until the amount was lowered to $100,000. However, when this plan was revealed to Mr. Bentley Fisher, he paid me a visit in jail, and I decided to fire Mark Bednar and to refuse any other distribution for pay to Michael Griffin. R has previously agreed to pay 15% of any distribution that he could obtain through negotiations with my son. Bednar could obtain by agreement with Donald Jr. He would get 15%, and that would be his portion. So, at one point, I was requested as personal representative on all three estates to distribute $1.5 million, split between Jr., Griffith, and Bednar, would receive 15% of Griffin's portion, so that you understand. I refused, and I ended all negotiations except a $10,000 agreement that was to be used for my care and well-being, and as you already know, Your Honor, I lost 115 pounds in jail, over a third of my body weight. Because of my actions, Michael Griffin sat down on my case. He received over 16 continuances. Actually, it's over 20 if you consider all of the ones where he actually appeared for other motions. Over the next 4 years before trial, at 51 months in jail and 54 months after the gruesome discovery of my family members. After 9 months, I was declared indigent, and I was told finally that Mr. Griffith was going to get the big ball rolling by his then legal assistant, a woman known only to me as Miss Leslie. That was her first name. She brought indigency papers for me to sign. This motion for indigency, I believe, was filed with the court on June the 23rd, 2016, my mother's birthday. On January the 5th, 2016, discovery documentation, that's January the 5th, 2016. Discovery documentation was received by Mr. Michael Griffith, and the portion that I received was forwarded to me on January the 13th, 2015. Upon reception, I immediately hand-numbered every page, which was printed one-sided on 8.5 by 11 xerographic paper. I went to work. I wrote my observations on the blank back of each and every sheet, numbered 1 through 1,151 pages, with over 1,000 pages of photographs, and my explanations for the photographs was on each blank back. Let's see. These notes were written in the words of a $10 an hour security officer, namely that would be me, Your Honor. At that time, I spent my days in jail, downstairs, since my cell in Orange Park was 11B on the second floor, on the second level. I was in the day room playing chess and checkers and cards with everybody else and watching television. As I mentioned, all of these discovery documents were sitting on an open shelf in my room. You want, I've never been arrested for anything in my life. I had no idea that these people did this kind of thing to people. Well, not only were my documents page numbered, but every written observation on the back blank black had been dated the date that I wrote it. Okay? And the date was written at the top of each page. Included in the discovery were several copies of my arrest report and my offense reports. These discovery documents, 1,151 pages, were for the use of my attorney, Michael Griffin, and he was instructed to keep this entire document intact. It was numbered for cause, to protect the integrity and the usefulness of the document, so that if any pages were ever removed or lost, that I would be aware at once. This document was critical notes needed for my use during my testimony. I requested that this discovery documents, I requested them twice during the course of the trial. At no time did you ever see a document in front of me on this table for my reference. This entire trial was recorded. There were 4 or 5 amended discoveries received over the course of my several years in jail. Each amended discovery was also numbered, but with a qualifier, so that if you threw it on the floor, I could still put it back. I could recollate it. Each amended discovery was handled exactly like the original discovery, with notes written on the back of each page. It was one-sided, so I took this page, I saw the information on it, I flipped it over, and I wrote what I wanted to say about it on the blank back. I lost my place. Give me a moment. Each amended discovery was handled exactly like the original discovery, with the notes on the back of each page, including the date that the notes were written. At no time was there any amended discovery before me on this bench for my use during this trial. After several months in jail, I received 26 depositions. There's the key. Printed one-sided on 8.5 by 11-inch xerographic paper, like the discovery. These depositions were kept in the exact order in which they were received, page numbered in order from page 1 through page 595 to match them. Each separate page had my comments handwritten on the back individually, just like the different discoveries. And each page was dated at the top as to when these notes were written. At no time during trial phase 1 did you ever see any depositions before me on this bench table. I cannot recall the exact number of pages in these amended discoveries, but I do know that one was for 101 pages, another one was for 77 pages, and I can't remember the others. All prepared for trial, but they were all processed the same. Twice during the course of phase 1, I asked Mrs. Wilson, my lead attorney, for my discovery. I offered to point out information vital to my defense, which she was apparently not familiar with, and still I was not given the vital notes. Mrs. Sharon K. Wilson cross-examined Marlon Purifoy. She never showed a single document or a single page from the original discovery with the detailed notes, all of which were dated in January 2016, to the jury. Purifoy was not removed for several months until after June of 2016 from my pod. All of these notes were finished before the end of January. Purifoy, an habitual offender and a prison reoffender, was desperate to make a deal, so he stole information and then mixed lies with the truth in order to deceive and confuse what I thought was a wonderful jury. Purifoy, facing life in prison, was given a 30-year cap on his sentence because of his habitual offender status. Had he been sentenced to a straight 30 years, it would have doubled. That is, to 60 years. And he is eligible for a further reduction only if I'm found guilty and I receive a sentence. His benefits he has enjoyed, even as he testified here in your shadow. Mrs. Wilson also cross-examined Christine Rollins. This was because Mr. Griffin was not able to cross-examine his own client. Mr. Griffin accepted payment from Mrs. Rollins in 2018, I believe, and handled her case for stealing drugs or valuables from the sheriff's evidence locker. Included in notes from discovery and from these depositions were my allegations that $16,158 was reported as retrieved by the sheriff's investigators and sent to the sheriff's evidence locker. It was unknown to me until a few months before trial that Mrs. Rollins was even the lead crime scene technician for the first 2 days. They made it appear through Ms. Ceda's deposition and through the deposition of Eli Poas that she wasn't even there, Your Honor. If you read their depositions, you'll see that. Mrs. Rollins was the lead crime scene technician for the first 2 days, and Mr. Griffin told me that she actually took in almost 90%, about 90%, he believed, of the evidence from the crime scene. Right? Now, I believe she was lead crime scene for both days, but they seemed to rotate, so it's possible she wasn't the lead crime scene technician on the second day. But after nearly 2 years, I received an amended discovery showing that the money had been received at the evidence locker of the Sheriff's Department in total $13,200. Now, this was nearly $3,000 missing between the crime scene and the locker. I requested Mrs. Wilson to bring this up, but she stated she was not sure about the amounts. She knew the $13,200, but she wasn't sure about the other amount. I said to her, give me my original discovery and I'll show you. This information was known by both my attorneys and was critical to my defense. Just a few weeks before the trial began, I asked for Mrs. Wilson's opinion because I wanted to testify first for the defense. In a letter that was held by jail authorities for over 2 months, Mrs. Wilson had responded. I had in my letter reminded her of several critical points that only I could address. Now, when the letter of response was finally delivered by correction officers at jail 2 months after she mailed it, or almost 2 months after she mailed it, they said that the reason why was because the letter had fallen behind a file cabinet and they couldn't find it. So that's why they didn't give it to me. They gave it to me on the 19th before we had the hearing on the 20th of December. Mrs. Wilson discouraged my desire to testify, and she sent a case law showing that if I attempted to speak out, that I would be bound, I could be bound or gagged, or I could even be removed from my own trial. She stated both her and Mr. Griffin agreed that if I testified, the questions would be very narrow scoped and limited. Now, during the trial, almost every witness appeared with their individual notes for reference. I didn't have mine. You, Judge Dan Heiser, will recall that I requested a Nelson hearing at the beginning of jury selection. I do not believe that Michael can even now produce these critical notes on numbered documents. Judge Dan Heiser, you will recall that during the course of events that led to this trial here, that I had to issue 2 waivers to Mr. Griffin in order to keep him on my case. One waiver was because after over 2 years in jail, I learned that Michael Griffin was not qualified to handle a death penalty case in a hearing that we had with one of the court officers who made that known. This information was read into the record. The second waiver was because he created a conflict when he accepted Christine Rawlings' case. He took her money after he took my $95,000. In between, he attempted to withdraw from my case on April the 30th, 2018. Although I had sat in jail since October the 27th, 2015, I was under pressure to hang on to this guy. I mean, he's going to walk away with $95,000 for free. I requested he return my money and he could be excused, but he refused to return my money to me. So I agreed to waive my rights after all that time in jail. During the course of the phase 1, I requested, as previously, that several critical witnesses be called to testify. The following list of persons were absolutely critical for my defense and my estimation: Mr. Kendrick Washington, Mr. Marcus Hickson, Mrs. Penny Crittington, the wife of George Crittington, Sergeant Kevin Coxwell, who was the head of robbery homicide at the time, and I had his deposition. He was Enfinger's boss, and he was head of robbery homicide for the Escambia County Sheriff's Department. Mr. Washington was Purifoy's bunkie after he was removed from my pod across the hall to the blue pod. Mark Hickson was my bunkie for 13 months, and he knew that I would never discuss my case with anybody for any reason. You would have had to cut my finger off, Your Honor, to get me to discuss my case. And I just want to add right here one thing. Marlon Purifoy even knew that the gate lock was unlocked. I didn't know that myself, Your Honor, until I received Maceda's deposition months after he left. I don't know where he got that. Mark Hickson, who was my bunkie for 13 months, and he knew that I would never discuss my case with anyone, as evidenced by a meeting that he had with Sharon Wilson. Griffith failed to interview Mr. Washington, even though I requested it several times. First, Kendrick was in here. He was in here for months. I notified Mr. Griffin. He never sent anybody to talk to him. Then he was rearrested again. I notified him again, and he never questioned him again. And then when we get into court, he says, I don't want to call him because he's on the run. I don't know what he's going to say. Well, no wonder you didn't know what he was going to say. You wouldn't send anybody to talk to the man. Washington was rearrested and spent nearly a year in jail later also. Now, Sergeant Kevin Coxwell stated on his depositions, on the depositions I'm talking about, and you got the line numbers and page numbers right there, Your Honor. He stated on his deposition that he knew that Richard stopped on his way home that deadly Tuesday, and that he called home on his way after work. He states that he knew that the cameras were up and functioning during the murders. When I requested the phone numbers for the house phone or Richard's cell phone, I was told by Mr. Griffin that they were not available. Mr. Griffin told me that these cell phone and house phone records were not available. Mr. Griffin pointed out that Richard's encryption on his phone was unbreakable. Unbreakable. The cameras had motion detectors, and via a special application, they sent email or text not only to Richard's phone, but to Richard's computer at work, according to my mother's belief. Now, Richard had over 51,000 emails or texts on his phone, according to Homeland Security Chief of Internal Security in Washington, D.C., on his letterhead. That's included in my discovery. The letters were included in discoveries. The point is that when the emails and the texts stopped coming to his phone, and according to Mom, to his computer at Torrey Field, when I asked for the phone records, when did these emails and texts stop coming in, Your Honor? When did they stop? If he's being notified electronically through transmissions, my electronics expert that you gave me, he hasn't even been here. He hasn't even testified. Now, when did the emails and the text stop coming to his phone? according to Mama, to his computer at Coyfield also. When I asked for the phone records, Griffin stated, oh, well, you know, the little dog, which was a Westie, and not a Pomeranian. Everybody in the jail is joking me about it being a Pomeranian. This dog weighed almost 40 pounds, Your Honor. This was a Westie. He's a little dog, but he's compact and hit. His vet records would be available at a veterinarian that would be on 9 Mile Road near Pine Forest. Near that. I'm not sure what veterinarian it is, but the records would be available there about how much the dog actually weighed. He said the dog could have been setting it off. I said, well, Mr. Griffin, the little dog didn't take the cameras down and throw them in the trash afterwards, because that's when the emails would have stopped, was when it was thrown into the trash. Now, George Crittenden was interviewed on 7/28/15 by Sergeant Coxwell. He had absolutely no statement to make at that time to Mr. Coxwell. But on August the 28th, 2015, he could tell investigators how many cigarettes I smoked 3 days before the wellness check on Friday, over a month before. During cross-examination, I requested a simple question by Mr. Griffin, and this man wouldn't ask that question. That question was, what time is dinner, Mr. Crittenden? What time is dinner? You've been retired for 12 years. You know what time you eat dinner probably every day of your life out of habit. You knew to put your sockets away because you knew it was getting close to dinner time. You said that you were sitting at your dinner table and you saw me drive away or Richard drive in. You couldn't give us any time frame? You're wrong. George Crittenden was interviewed on 7/28/15 by Sergeant Coxwell, and he had no statement. On August the 28th, after he spoke to Wayne Wright from the state's attorney's office, he could tell investigators how many cigarettes I smoked that day. 3 times, 3 days before the wellness check even happened. Mr. Crittenden remembered this a month later about something that happened after all the excitement when they found my slaughtered family. I smoked 3 days before the wellness check on Friday, over a month before. During cross-examination, I requested a simple question: what time is dinner every day for 12 years of retirement? Mr. Crittenden could not be sure of the time that Richard left work Tuesday. He didn't know that Richard left work at 6:36 p.m. Now, in fact, he couldn't be sure of anything at all when it came to time. He never wore. According to the climatological survey, sunset was at 6:46 p.m., not 7:46 p.m. local standard time. Local standard time, not daylight savings time, and not central time. And if you read it, you're going to find that that is visual observations. That's what local standard time means. Crittenden's only estimation was that it was daylight on his deposition because Mr. Hartung's headlights on his distinctive Lincoln were not on his car. And during the course of investigation, authorities were called back to remove money that Mr. Crittenden he called the sheriff's department, Your Honor, and told the sheriff's department there was all this money in the back of Richard's SUV that was still sitting there at the house days after the murder. When the sheriff's department came back, they looked in the car, there was no money there. And he said, well, it was there. And they said, Mr. Crittenden, we searched the cars on the day of the wellness check. There's never been any money in it. The cars are sitting here locked. Now, during the course of the investigation, authorities were called back to remove all that money from Richard's SUV by Mr. Crittenden, money that didn't even exist. And yet, Griffin never asked a single question. What time is dinner? What time is dinner? Penny Crittenden was next door with her husband preparing and eating dinner right beside George. All the windows inside their home was wide open because there was no air conditioning on July 28, 2015. She was asked by Griffin, why were you even called as a witness on her deposition? She replied, I don't know. She had nothing to say. She saw nothing, she heard nothing, she smelled nothing, and she felt nothing. But here's the interesting part. She replied, I don't know. So then the prosecutor in cross asked one question. I'm going to have to paraphrase this because I do not have the papers in front of me, but I'm going to give you the gist of what her answer will be if we get her deposition and look at it. Mrs. Crittenden, how did you get back from the Friday when the deceased were discovered to the Tuesday when Mr. Hartung was here? It's the only question she asked, or that person asked. And to paraphrase her reply, Mrs. Crittenden answered, because the authorities gave us the dates and the times that they need. When she said us, sir, I submit she was talking about Mr. Crittenden. She was not called by either defense attorney, even after I was Neither was any question asked as to why Mrs. Minyard said, I did the autopsies first and then I went to the crime scene to do my investigation. Both attorneys knew that Matthew Winfinger had stated in his deposition that after he completed his interrogation of me on Friday afternoon, that he returned to the crime scene. Mr. Griffin asked him, he said, what did you do? What happened? Tell me about it. He said, well, when I got there, Mrs. Minyard was there. And Mr. Griffin said, was it Mrs. Minyard or was it her investigators? He stated that Mrs. Minyard was there, and when asked if it were indeed Minyard or her investigators, he described in detail how he and Minyard had gone in and looked at John's body where he was seated in the den, and at the splutter of the blood around and behind the body. Your Honor, there was blood in giant piles on the carpet that was never even touched by any of that bedding and clothing or whatever it was that was over top of them. These giant piles of blood were just out there in the opening. It goes back to the bugs, Your Honor. The bodies were still warm at the crime scene until at least 5:50 p.m. Now, let me go back. Let me digress. He described in detail how he and Minyard had looked at where John was seated in the den and at the spatter of blood. The bodies were still warm and still at the crime scene until at least 5:50 p.m. Mrs. Minyard lied, both on her deposition and years later at trial, but it was totally ignored by two supposedly seasoned attorneys. One of the two first responders, and I believe it was Tatum, it may have been Singleton, stated, we almost missed the bodies. On his deposition, he actually stated, we went in, we saw the door in front, we couldn't go that way, so we turned right, went into the kitchen, we went and searched every room, the door was closed to John's bedroom, and when they tried to push it open, there was a giant pile of clothes laying there. They came back out, they were getting ready to leave the house and clear the house. Your Honor, I submit that there was 3 dead bodies, and they claimed that the temperature inside the house was 85 degrees. There's 3 dead bodies inside this house for 3 days, Your Honor. I submit that when you open that door, it would have slapped you right in the face. We almost missed the bodies. He was never called. There's 3 dead bodies closed up in a hot house, supposedly for almost 3 days, about 65, 70 hours, 72 hours. There's no smell. There's piles of blood that have ran down in pictures and the discovery. There's even blood spatter all over the ceiling in that back bedroom from both chairs. That is the recliner where Mother was murdered and the love seat where John William Smith was murdered. There were piles of blood on the floor behind the chair where they burned down. This was not covered by clothes or sheets, blankets, or anything up on the bodies, but that was exposed for all these days and hours. Again, no comments were made by Mr. Griffin. The little Westie dog weighed nearly 40 pounds. I'm sure Mama told me it's about 40 pounds. We can get the vet records. Pictures in Discovery shows a gloved hand holding the food and the water bottle. In contrast, you can clearly see how tiny those little bowls were in the officer's hand. According to Crittenden, I had left before dark on Tuesday. The bowls were still full 3 days later. Yes, I am an animal lover. I love animals very much. And I may have filled those bowls before I left at 5:30 p.m. But 3 days later, that's the only thing that dog had to eat, Your Honor. What did the dog eat? He didn't eat none of the bodies. The bowls were still full 3 days later. There was feces and urine reported as being all over the house. On Wednesday, and this is where I ran out of ink, Your Honor. You can see it clearly here. This is where I ran out of ink. Thank God for a woman at the jail who worked in the chaplain's office that got me another little flex pen so I could finish this letter. On Wednesday, as I awaited the jurors return their verdict, I asked Mr. Sharon Wilson for her opinion. This as we awaited the arrival of Michael Griffin, who was still out of the court, so that the jury could then return. Mrs. Wilson replied, after I asked her opinion, she said, "You're a stupid asshole." I said, "What? What did you say?" And Mrs. Wilson said, "I said you're a stupid asshole." I I respectfully ask Judge Thomas Danheiser to reconsider my motion for the removal of Michael J. Griffin as my attorney. I request also that Sharon Wilson be removed before Phase 2 of this miscarriage of justice can continue. I submit that you, Judge Danheiser, examine the testimony ex parte of Monica Jordan yourself. You grilled her for about an hour and a half, during which time the names and addresses of 31 possible witnesses for Phase 2 were presented. This past Friday, during testimony, Mrs. Wilson revealed that only 2 doctors paid for by the state would be called to testify. On June the 3rd, 2019, a continuance was issued, partly because Mrs. Wilson had not prepared witnesses, and now, almost 7 months later, not a single subpoena has been requested. Michael had names of at least 12 character witnesses, including Michael Brooks. Michael Brooks at Sacred Heart Hospital, been head of security there for G4S for over 20 years. My work supervisor at Sacred Heart for 9 years and 9 months until I was suspended. And I might add here, Your Honor, that the reason why I wrote the letter of resignation, and Mr. Griffin actually wrote the letter, I just signed it. The reason why I sent the letter was because I wanted to get unemployment. I was on food stamps and unemployment, Your Honor. I gave $100,000 to some high priest that rode off on a Harley while I was on food stamps. Nine years and 9 months. He was aware of the integrity award that was mentioned in cross-examination to Mark Bailey. That award for saving a young woman's life was printed internationally in G4S Secure Solution newspapers sent to every employee, including Mark Bailey. Despite my request, it was never revealed to this wonderful jury that Bailey had been beaten until his skull was crushed by inmates in his former correctional center job, until he was forced onto full disability for years. His disability was lowered and then removed, and that's why he came to work at G4S. Michael Griffin was given names and information regarding conversations with several of my neighbors on that Tuesday afternoon. Several of my neighbors. I told him what we talked about. None of these neighbors were interviewed except Arnold and Amy Johnson next door. Mr. Griffin, as you know, or you may not know, Mr. Griffin lost his investigator. So he had to hire another man named Greg Grover, who actually said he couldn't get in touch with none of these people. Even though all these people are, look, the Herschelbergers, they're always home. Amy babysits. Amy Johnson. Except Arnold and Amy Johnson next door. Michael Griffin was aware that Amy's friend Diane had driven me to Bank of America to make that deposit on August 3rd that they were so proud of over there. 2015, Mr. Griffin knew that Diane went into the bank with me and witnessed that several $100s, I've got $900, but I'm not sure the exact amount, Your Honor, was all $1 bills in envelopes marked with the dates that they were sealed going back nearly 15 years, Dave Ramsey style. Dave Ramsey, the talk show host, debt-free. Everyone in attendance saw the damage of my 1989 Lincoln Town car. You saw the picture, Your Honor. You saw the crushed fender up there. Now, Michael Griffin and Sharon Wilson both knew that accident occurred, that damaged that right rear fender on August the 18th, I believe it was 2013, resulted in a settlement of $33,000. $33,000 in May, I believe, of 2014. A windfall for a $10 an hour security guard, Your Honor. This settlement was handled by Marcus Michaels right here in Pensacola. Right here locally. None of this was ever mentioned during the trial. I could go on and on, some more, for hours. I had 9 notebooks, which included one pictured in the Brady violation motion. You'll remember the picture, Your Honor, of the Brady violation of discovery rules. That we had a motion that was denied for a dismissal and discovery rules violation. There were 7 composition notebooks written before I was even arrested. Each had 200 pages written front and back, Your Honor. Those notebooks, you never saw them before me at this bench. And it's all on film. I mean, they filmed the whole show. In book number 1, I detailed a quid pro quo with Homeland Security agents Jacoby and Palomino. As a result of this secret meeting, they didn't know anything about it, Your Honor. I called Donald Hartung Jr. in Virginia Beach, Virginia. In my notebook, there is attached a business card. Every note in every one of those notebooks is dated and timed, Your Honor. dated and timed, in those notebooks, is an attached business card from this 1/2 hour meeting, secret meeting, held between me and Jacoby and Palomino, where my brother's sexuality was discussed. They showed me a picture of Richard with a girl's arm around him, and they said, "What's going on with these guys?" They had asked me during the search on August 3rd if they could come back and talk to me, if I would talk to them, telling me that they had nothing to do with Escambia County, nothing to do with the Sheriff's Department whatsoever. And anything I told them, they would keep it in absolute sacred secret. And so they came and talked to me. And they said, in all of our searches throughout their home and through your home, this is the only picture we could find of either one of these boys was a girl. Was there something wrong with them? And do you know who this woman is? And I told them, I said, yes, sir. I said, that's F.B.F. Madison. She's a girl that came down with, she's my girlfriend. Now, at the time, I did not remember when the picture was taken, but later on, I did remember that it was taken during a trip that my brother made to Virginia Beach to visit me at my apartment at Mayflower Seaside Apartments.
Mr. Hartung, let me ask you, how many more pages do you have?
This is the last page, and it's only a half a page.
Okay, very good.
Donald Hartung Jr. in Virginia Beach. I called him and asked him about what happened with John, because this was the sexuality thing came out. That's why I never intended to make it look like John caused this to happen. John didn't cause anything to happen. In Virginia Beach, Virginia. In my notebooks, there is attached business card from this 1/2 hour meeting where my brother's sexuality were discussed. Once again, Griffin refused to produce my notes, my notebooks, my discoveries, my depositions, or any other important documents, such as 13 fold-over inserts that I made. Those would be the only pages missing out of my discovery if it was all brought here, because I took those pages out to show how police manipulated the crime scene. They took a photo of this here, and then I guess somebody else came in later, 400 or 500 pages later, they took another photo of the same thing, but now the wallet's open and the money's hanging out. The wallet's on the other side of the valet. Kind of like the trash cans that Mrs. Wilson, when she made her little pinup presentation, Your Honor, which I thought was really, really good. My depositions or any other of the important documents, such as hundreds of letters. I've sent this man, I know, at least 1,000 pages just in letters, and none of them was casual conversations. They were all about my case. Mr. Griffin didn't even scratch the surface of my case. Not even the surface. Hundreds of letters sent to him over 4 years. I have sitting beside me here Monica Jordan, needing paperwork that she needed in order to do her mitigation. She went to Mr. Griffin's office, and she told me that all of my stuff was found in a back closet, in a back room of Griffin's office. She said it was the biggest mess she'd ever seen. After 51 months in jail, I had finally gotten my day in court. Thank you, Your Honor. I respectfully request a mistrial. And I also request reconsideration of my earlier motions, Mr. Griffin's motions for acquittal, and also one other thing I would like to point out, because I had to give the pen back to the lady, but Your Honor, there was full profile DNA in Richard's front pocket that was not in the FBI database. It's going to be in my documents. This was so eat up by the time they got through doing the STR that it was down to a smidgen. It didn't matter. The original documentation said that my DNA was not found on any of these bodies, nor was it found on the hammer. After 4 years of manipulation, after 4 years, now, suddenly, instead of there being an unknown person's full DNA profile in Richard's left front pocket, there's only a smidgen there. And now, suddenly, my DNA's appeared on the back of this belt. Well, Your Honor, I laid on the floor where he died, played video games for hours with my brothers, the TVs right above it. That's where I laid when me and Richard and John played video games together. Now, when it was just me and John, I sat up in the chairs. I lay there, Your Honor, I would ask you to take a look at Ballard versus State, Your Honor, a case in which my DNA in your house where a crime has been committed, Your Honor. That's real evidence. But my DNA in my own home or in my mother's home where I frequented all the time, Your Honor, that's not even real evidence. One sneeze in that house where that black case was laying in there, Richard used to keep his checkbook on top of the refrigerator. I've moved it a million times. You know how many times I've touched that hammer? I put hurricane clips in the wall for Ivan with that very hammer. Hurricane clips into concrete to put up boards. None of this was brought out in trial. One sneeze could have just covered that black case with DNA in that house. That case could have laid around in that room forever. The pill box, I mentioned it to them, they didn't mention it. The pill box had laid in that kitchen for years. There's no proof that the medicine that's in there was even Mama's. It could have been John's, for all we know. But one thing's for sure, it wasn't her current prescription. I'd be willing to bet you, because if Lady Mama didn't use that, John memorized Mama's medicine and he gave her her medicine. He didn't need no pill box for Mama. And I would submit also that when Mrs. Jensen did her PowerPoint, she kept running down and saying things. There was not a single objection raised. She said, Mr. Hartung missed.
Sir, look at me when you're talking.
Mr. Hartung missed when he shot Richard. He tried to shoot Richard in the head. No objection. She said that Mr. Hartung forgot to take the trash out when he left. No objection. All pure speculation. Pure speculation. I also would point out that she had a fancy Star Wars type PowerPoint presentation where she had the numbers floating around, and then they flashed up there showing how much money my family had. I had no knowledge of any of that, right? I had no idea they had that kind of money. And then Mr. Griffin gets up there with a Give-A-Show projector. I mean, not literally, but poor fella, he didn't even know how to operate the thing, hardly. He gets to the capstone of our defense, and that's the boulders. He skips over it. It's not even up there for 10 seconds. He skips right over it. And he never presented that picture with that hand showing how tiny those boulders were to that jury. Now, as I said, I could go on and on and on, but I request a mistrial for lack of proper representation. I was told, I received a letter from Mrs. Jensen, and I was told that if I testified, they would control the questions, that they would be narrowly scoped. Basically just yes and no. And you're not going to be able to tell the jury all this stuff. I loved my jury. They paid attention. They paid close attention. But, Your Honor, they were duped. You were duped. Andrea Minyard said, I did the autopsies first, and then I went to the crime scene. Your Honor, we know that's not true. Both of these attorneys know that's not true. You're one. Thank you.
Okay. All right, I'm going to let the counsel give the input they want, but initially, based on everything you said, assuming all that's true, nothing is a basis legally for a mistrial, I would say regarding Nelson, Nelson hearing is inapplicable to Mr. Griffith as he's privately retained. However, there's been no evidence that Mr. Griffith or Ms. Wilson have been ineffective. In fact, through my observations, they've been extremely effective and worked diligently on this case and litigated this case extremely well to the jury, explored all kinds of areas I wouldn't even have thought of. And you mentioned Richardson, but there simply wasn't even a Richardson issue you even brought up. I'll let you respond briefly, and then I'm going to let
Yes,
counsel
sir. Well,
give
the
the
reason
input
for
they
the
want.
Richardson was because it was exculpatory evidence that was never presented in my case. And also, I would like to request that this information be entered into the record for possibly for future appeal.
That's fine. It'll be Mr. Hartung, Exhibit 1. So you could bring. Did counsel want to review it before it's brought up? And also, I would also note you've been here every day during the course of the trial, of course. I've been here readily available to you. You knowingly, voluntarily, and willfully waived your right to testify in this case. That was a decision you made. We had
I was browbeaten, Your Honor.
well, as I will state for the record, you were not browbeaten. I've observed body language, entire interaction between you and your counsel, and
Mr.
spoke to
Griffin
you.
promised me he would bring these
I let you
issues up.
speak for almost an hour, sir. Wait a second.
Yes, sir.
You were 2 feet from me when we had a conversation about your decision not to testify. Your demeanor was very calm. You contemplated. You thought about it. It was clear. It was your knowing, willful decision. So that was clear. I personally observed that.
May I say one last thing?
Yes, sir.
I'm a $10 hour security guard, Your Honor. I couldn't possibly be expected to go up against 4 seasoned attorneys. I was duped and I was tricked, and I'm willing to admit it. And so were you. You have the evidence there. I had asked that those documents be presented. They were not presented. I was not given anything. Every single person that came up there to testify, I think, except for my son, had their notes with them. I was not given my notes. You never saw them on this table. I asked for them 4 times.
Okay. Did defense counsel want to give you input?
Judge, I think that based upon what Mr. Hartung has alleged, that all 3 of us, Ms. Jordan, Ms. Wilson, and myself, have a conflict in further representation of Mr. Hartung. And for the record, all of Mr. Hartung's notes and letters were brought to the courthouse, and they sat right here next to where Mr. Hartung is currently sitting.
They were dispersed, Your Honor.
Sir, you gotta let me speak, sir.
They were in binders that were sitting right here.
Why didn't you give them to me?
Sir, wait a second. Anything else, Mr. Griffith?
No,
Ms.
sir.
Wilson, anything?
Yes, Your Honor. Just that in the statements he's just made, Mr. Hartung has said things that were not true. He's made accusations about each of us. And I do believe that creates a conflict with each of us. And
I disagree. The defendant can't create conflict because he makes derogatory statements about counsel, none of which, based on my observations, or even have any basis in fact. And even if they did, it wouldn't make any difference. There's no ethical conflict. It's normal course of business that defendants either don't like. In fact, if all the people in the system, first person they don't like is their counsel. Second, prosecutor. Third, the judge. Judge is way down the list usually. But first, it's always their counsel, because their counsel usually can't give them a magic wand to make the case go away. And that's when defendants are disappointed. But there's been zero evidence that there's any legal conflict. And again, even everything Mr. Hartung, if accepted, is true, and much of it is patently not true from the record, wouldn't be a basis for mistrial or a basis for a conflict with counsel or mitigation expert. Mitigation expert has worked this case hard for, I don't know, a year and a half or so. And anyways, there's zero basis.
Just to clear the record, Judge, Ms. Jordan could testify that we had an entire office set aside for Mr. Hartung's file, and everything was indexed and in that office. It was not thrown in a closet anywhere.
And Judge, at this point, I am concerned about our ability to continue to represent Mr. Hartung and interact with him, which is something that we do have to do.
But that's a decision of his own. That is not, you have not created that. He can choose to communicate with you or not. That's not the basis for any change of these proceedings or a change of the expert or counsel. And Mr. Hartung initially, when this trial started, knowingly, intelligently decided to keep Mr. Griffith on this case. We went through that at the beginning of the trial.
Wouldn't you give him a money back?
We've already gone through the guilt phase.
And my remaining concern, Your Honor, would just be for Mr. Hartung's mental state at this point.
I have no concerns. He's very articulate. He keeps referring to this $10 an hour security guard, whether it's $10 an hour or $1,000 an hour. He's obviously intelligent. He's been coherent. He's been articulate. He's not been irrational in his discussions. So he may disagree with your strategy, but that's normal.
And Judge, with all due respect, I would say that he has been irrational in much of that statement.
But he's had a competency evaluation just a week and a half, 2 weeks ago, whatever. And I've observed nothing through this whole case. I've observed Mr. Hartung for hours. Again, I've not seen the first, quote, irrational act, inappropriate behavior, inappropriate body language. So that's all I can tell you.
The other thing, Judge, I'd like to put on the record, any conflicts I had with any witnesses were waived by Mr. Hartung. And additionally, at the end of jury selection, I requested the court confirm with Mr. Hartung he was satisfied. And at the end of the state's case, I asked the court to confirm with Mr. Hartung he was satisfied. He indicated he was. He didn't bring up any of those issues, and at no time did he bring up the fact that he wasn't reviewing his notes, which were sitting behind him in crates and labeled and filed chronologically in notebooks.
Okay, that's correct.
Your Honor,
Wait, one thing. Yes, sir, I'm going to let state give me input if they wish. Yes, Mr. Hartung.
The exculpatory evidence that was left out of my trial, Your Honor, Mr. Griffin had promised me he was going to bring a lot of that up in his closing statement when I decided not to testify.
Okay. State have any input?
No, Judge.
All right, so those are no rulings. All right, ready? Any other preliminary matters? You had an objection to some exhibit?
Yes.
Yes, sir.
Okay.
I think we sent it up to you, Judge, but there was a family tree Mr. Hartung provided to us yesterday. Have you had a chance to look at that?
Yes.
Okay. And we also sent out 2 Supreme Court of Florida cases, and we would just object to the extended family's history as not being relevant to Mr. Hartung, Judge. Anything about Mr. Hartung's childhood or what he went through personally obviously would be relevant and admissible, but anything outside of that we would argue is not relevant.
Bottom line, we're saying any issues with his relatives that there's no evidence impacted him, they're just simply irrelevant.
Yes, sir.
Defense?
Judge, this family tree was intended as a demonstrative exhibit, and I don't have to use this particular exhibit, but I would argue that Mr. Hartung is very much in this family tree as having been victimized by several different people, and the very fact that some of his other relatives have been victimized by the same people is pertinent as corroboration for what Mr. Hartung has said, as well as corroborating that there's a genetic effect and there's also an effect on a person who is raised in this type of circumstances, and that's my reason for eliciting this type of information.
Well, one, you haven't even introduced evidence yet. Certainly no exhibit can come in without an evidentiary foundation. So maybe at some point I'll agree that some of it's relevant, maybe the whole thing. But right now, I understand the state's argument, and there's certainly, I assume you're not testifying as an expert as to some genetic theory of hereditary mitigation. That would be kind of unique. I've never heard of that. I mean, there's some things on here from 1936 from some relatives, and I imagine you might be able to establish to me how that's relevant and admissible, but at this point, it'd be hard to imagine, but I'll be open-minded and just hear what the defense has to say. But preliminarily, unless the defense ties this in as to be relevant to Mr. Hartung, this or anything else wouldn't come in. That's just basic evidence. So that's just kind of a general commentary. Again, some of this or all of it may come in if you establish the relevance. So I'm not going to quote exclude it yet because you haven't had the opportunity to lay a foundation, but we'll just address it when we get to that.
Just
So
as we
it wouldn't be used in any opening statement, sir.
Sure, Judge, and just as we did in the guilt phase, if we get to the point where we're going to start eliciting that testimony, it may be proper to proffer at that point.
Okay. All right. Anything else?
Not from the state.
Judge, in some pretrial motions several months ago, I had objected to the admission of any victim impact evidence, and I would renew that objection.
All right. The objections overruled. All right. Is there any objection to the preliminary instructions and penalty proceedings as presented by the state? The 2-page 7.2. And the instruction is just 2 pages, correct?
Yes, sir.
It's the standard, the Supreme Court form, correct?
Yes, sir.
Any objection?
No objection.
All right. Anything else before we bring the jury?
Not from the state. Are you bringing the jury right now?
I'm ready.
Oh, were you waiting on me? I'm sorry.
Judge, I know the court just made a finding of competency and you had no concern based on your visual observations of what Mr. Hartung said, how he's conducted himself, and so forth. Dr. Turner is in here as well. I don't know if the court needs to take any testimony from him about his beliefs on competency, but it's my understanding he has no issue or no concern about Mr. Hartung's competency. But I do believe the court will need to make a written finding or a written order stating why you believe he's competent.
Well, I don't know if there's been a real formal suggestion of incompetency.
I understand that, Your Honor. I had a previous case, though, where something similar happened, and he got reversed and sent back for a non-proton hearing to determine if the court could find him competent.
Isn't defense supposed to articulate the basis for their?
I believe she gave a basis. I don't know.
She thought there was irrational statements. Okay, Dr. Turner here.
Yes.
State line calling.
State calls Dr. Brett Turner. This way.
Good morning. Can you raise your right hand, please? Do you swear or affirm the testimony you give to be the truth, so help you God?
I do.
Thank you. Please be seated.
Morning, Doctor. Can you state your
Morning.
name for the record?
Brett Wayne Turner.
And just briefly, can you give the court your qualifications on what you do?
Sure. I'm a licensed psychologist in Florida, and I've been appointed by the court hundreds of times to conduct competency evaluations and a variety of other forensic evaluations
And have you testified to those findings before?
multiple times.
Okay. Have your state appointed or court appointed for the state of Florida versus Donald Hartung? Is that correct?
That's correct.
Okay. And have you had a chance to meet with Mr. Hartung?
I have.
Okay. And how long were you in the courtroom today?
I think I've been here approximately 30 minutes.
Did you get to see Mr. Hartung speak?
I did.
Okay. Do you know how long you heard that?
20 minutes of that time, I guess.
When you met with Mr. Hartung in regards to your testimony today, for which you were supposed to be called for, did you have any concern about his competency then?
No, he was very articulate and seemed to understand the legal system and his circumstances well when I met with him in the jail.
And he answered your questions appropriately?
Yes.
Conducted himself appropriately?
Yes.
Okay, as you observed him today, did you see anything that caused you any concern as to his competency?
No, he seemed to have a good understanding of the complaints that he was lodging and the workings of the court system.
Nothing about what he said or how he acted caused you any concern as to his competency?
No.
Ms. Wilson?
Dr. Turner, normally when you administer a competency exam or evaluation, you don't just sit in a courtroom and listen to someone talk, correct?
That's correct.
It usually is much more involved than that.
Yes.
Thank you.
And when you saw Mr. Hartung for your evaluation as to the Phase 2, was that January 31st of this year?
That's correct.
Thank you, sir.
All right. Thank you, sir. All right. Again, based on any further evidence,
No, sir.
No, sir.
based on the testimony of Dr. Turner, plus my days and months and years of contact with Mr. Hartung, observing everything about him, listening to the speech. In fact, I would put him at the top end of few percentiles of competency and intelligence of defendants who I've had in the system. So not only is he not competent, he's absolutely competent, and one of the more intelligent and coherent individuals have been defendants in 10 years I've been a judge. So I'll find he is certainly competent to proceed.
Will the court prepare a written order?
Yes.
Thank you. That's it.
Ms. Wilson.
Judge, if I could just place an objection on the record to this method of finding Mr. Hartung competent.
Anything further about the method?
It's not actually a competency evaluation, and having one witness observe him for a few minutes of a long tirade is just simply not a competency evaluation.
Well, it wasn't a tirade. He effectively testified. He wasn't a tirade. He was very spoke appropriately. So I don't think it's a tirade. The doctor testified he met with him personally, and we have the competency evaluation, which was still chronologically appropriately considered. That was just done 3 weeks ago. Based on, again, all of that, plus the evidence today, showing Mr. Hartung is clearly competent to proceed. All right, ready for the jury?
Yes, sir.
and I'll follow written verdict. All right, let's bring jury in, please. All right, our jury is back. Please be seated.